and we hope to showcase a wide variety of policy work undertaken by the New South Wales Government. To preview just the next few months, Amy Brown from DPC and Nick Willing from Police will be talking to us about forecasting the social impacts of COVID-19. And Sean Cummings from New South Wales Treasury will be addressing Aboriginal economic wellbeing. We will also welcome our first international speaker, Paul de Hart from the Utrecht University in the Netherlands. Paul is an academic focusing on the concept of policy success, and he'll draw on observations from Europe and from his time working in Australia. And if you're a policy nerd like me, you can get some pre-reading done in already. Check out his recent books, Great Policy Successes and Successful Public Policy Lessons Learned from Australia and New Zealand. The Auditor General, Margaret Crawford, will also be joining us to talk about the Audit Office reviews and how we can make better use of them. But today we are joined by Rose Webb, who is currently Deputy Secretary of the Better Regulation Division in the New South Wales Department of Customs Service. In this role, she is also New South Wales Fair Trading Commissioner and responsible for Safe Work New South Wales and a number of other regulatory functions. Rose joined the New South Wales Government after spending 3.5 years at the Hong Kong Competition Commission, including as CEO, and she worked at the Australian Competition and Consumer Commission, including as New South Wales Regional Director and Executive General Manager for Mergers and Adjudication. Rose has also worked in environmental regulation in the Commonwealth, and earlier in her career she worked at the Australian Securities and Investments Commission. Today, Rose will be sharing her ideas and some case studies on collaboration between policy teams and regulators, who have insight into how laws will be applied in practice and valuable knowledge for policy development, and also have a critical role in implementation. There will be opportunity for you to ask questions after the presentation, and I'll put more instructions on how to do this in the chat shortly. But Rose, I'll hand over to you as we load up your slides.
Great, thanks very much, Louisa, and thanks for everyone for inviting me today and for coming along. So I've just got some slides that hopefully India is managing to wrangle for me. I didn't want to trust my own technical skills. Great, thanks. So as Louisa mentioned, my topic today is collaboration between policymakers and regulators, and this is sort of a topic dear to my heart because, as Louisa mentioned, I've been a regulator for pretty much all of my career, but of course I've had many interactions during the course of that with policymakers in a whole different, loads of different environments and circumstances. I thought I might just start first of all with just talking about some of the structural issues that might lead to enhancing or not collaboration between policymakers and regulators. So maybe India, if you can move to the next slide. I don't know if you're able to put it onto a slideshow as well, just to help people see it a little bit clearer. Just not quite sure. Sorry about this.
Sorry, just to say, if you click Enable Editing, you should be able to put it into the slideshow setting.
Right. Great, thanks. Excellent, thanks so much. I really do appreciate the assistance with this. I think there's a few different models that I've seen in my time of how people think about the different roles and the relationships between regulators and policymakers. The first up point there, I've called it the purist model, and this comes primarily for me from my experience working in the Commonwealth, where there was quite a trend towards having very independent regulatory agencies, such as ASIC and the ACCC that I both worked in, and then the policymakers, the people responsible for the laws that those agencies were administering, sat in the line department in Treasury or wherever it was, and there was often quite a sort of distinction between those two bunches of people, even though they were working, you know, towards the same objectives. I can remember we used to have quite a few debates when I worked in the ACCC about whether it was appropriate for the ACCC to have what we called a policy function. We weren't meaning making the legislation. We were talking about, I guess, small p policy. We wanted to put out various policies about how we were going to interpret the law in particular circumstances. And we always had a little bit of discussion, I'll put it that way, with Treasury about whether it was appropriate for a team to be called a policy team within an independent statutory agency. And so that was sort of the very pure model. And we had to call our small p policy team something different. And there was, this was sort of seen as quite a good thing because it did mean that the people who were administering the law were quite independent and separate from the people that were making the law. And I can sort of see a lot of reason for doing that. Particularly, it's good from both sides. I think in some ways it means that the person who makes the decisions about what the law should be does that in a sort of independent, with an independent focus and not with any buy-in from the people who are administering it. And it sort of worked quite well often for regulators because we could sort of work to the limits of what the law allowed us to do. And if we got complaints that we weren't doing anything, we could sort of quite rightly say, you know, we just administer this law, we don't make this law, go and talk to the policy people. And that helped with complaints, you know, both from the general public, but also from some of our government and ministers and things like that as well. So I think there's quite a bit in that model, but I think it does then lead to quite a bit of challenge sometime for law reform efforts and for making this collaboration work. So I'll come back to that a little bit later about how you do that. The other example I can give of this was when I was working in Hong Kong and I arrived to help set up the Competition Commission there, and there'd been a process for the previous 5 years of the policy people in the government department doing the hard yards in making the law, getting the law through the Hong Kong legislature, which was no mean feat, and promulgating the law. And then we all turned up and set up the regulator, but took as received the law that we had. And I think over time it showed a few gaps where possibly the people who were completely green to this policy area and were trying to do their best to create a new law probably put some things in place that really hampered what the regulator could do as well. So sometimes that independent pure model can actually sort of cause a lot of problems. I think the integrated approach is possibly the opposite end of the spectrum, where you have policy making function and regulation within the same structure. That's certainly what I have now in Better Regulation Division with the policy team is part of the division. And so therefore we do have some very good connections, and the examples I'll give a bit later will show how well we can make the collaboration work. But again, I guess it just, you know, no model is the right model. It can raise some issues where, you know, if our attempt at doing some form of regulation doesn't work, we're sort of flung back into fixing it by a policy fix, which might not always be the right solution to the problem. And again, it can sort of mean that a blurring of the line between the people who are making the law and the people who are interpreting the law and implementing the law. So I think there's sort of reasons why you have a different structure. But as I've got at the end of the slide there, I do think actually most of the time it really works out as a bit of a hybrid. There's rarely a circumstance where people are making policy completely in a vacuum and completely divorced from the people that will be implementing and you know, exercising the regulatory function once the legislation's in place. And it's rarely the case that even in a big division like mine, where we do have policy and regulatory functions, that we don't split them up. And so we have a very clearly identified and dedicated policy team that are quite separate from the people exercising the regulatory functions. Maybe just someone needs to go on mute, I think. A bit of background noise, thanks. So India, if you could just move on to the next slide. Okay, so I do think, and you probably say she would say that there's a lot of benefits from making sure that you get regulator input into policy making. I think it's sort of obvious that the people who are going to be implementing a particular piece of legislation or regulation probably have a very sort of practical approach to what will work and what won't work. They probably, depending on whether it's completely new policy area, but in most cases, they will have been out and about mixing with people from a sector down on the ground in a way that a policymaker probably never can get unless they do a really in-depth piece of research or customer inquiry before they start the policy process. A lot of what I find the people who are our inspectors can bring back to help us with doing our work generally, but also our policy work more better, is that they're just out and about talking to people who are actually trying to repair motor cars or run an asbestos removal business or whatever they're trying to do. And they do really have a sort of honest, they get the honest view, not sort of mediated through stakeholder representatives or industry associations. They actually see the people on the ground quite a lot. Sometimes also the people who are in the regulators have actually come from that sector, and that's where their expertise is. I know, we've got a lot of building inspectors in fair trading, and they have a detailed knowledge of how the plumbing law should work because they've actually been there doing plumbing for a lot of their career before they've joined us. Regulators can also assist with unpacking the problem that you're actually seeking to resolve. I think all of you probably buy into the idea that before we run around imposing more regulation, we need to actually think about what problem are we trying to solve for, and what is the answer to it? Is the answer to it some different policy approach, some regulation or legislation, or is it really just something that some sort of education campaign or some other remedy could actually resolve? And I think it's a really good exercise to make sure policymakers are unpacking the problem or working out why there's sort of some perceived market failure or a problem with how people are behaving. But I think regulators also can bring a lot to bear on why is this conduct happening out there, why are consumers not understanding this issue, why are business people behaving in this way? Is it just a sort of profit incentive, or do they genuinely think they're doing something good but it's perceived as something bad? So I do think in the same way that they bring the frontline view, they also just bring a bit of open-ended understanding about why these problems might be occurring and what the best solution is to them. And as I say in my third point, they bring a lot of practical focus to it, which I think is often a challenge for policymakers because you've got such a breadth of things that you have to do. You probably can read a lot about an industry or understand to a certain extent the various things that are operating on an industry, but maybe just don't have the same sort of practical experience that someone who's out there trying to regulate it. Feedback loop from regulators can really help with detection of unintended consequences or drafting errors. They're usually the first people on the line to hear if they head out to issue a penalty infringement notice on someone who seems not to be complying, to find that the reason the person can't comply is because there's some other conflicting requirement that they're complying with, and we've made a mistake here. We've put two requirements on the same person that are inconsistent, and somehow that has caused a problem. They'll often find, just drafting errors when they try and exert some sort of regulatory power and then find that the way the legislation is drafted doesn't actually allow that to happen. Sometimes they could just be drafting errors, but sometimes there's some more fundamental problems where people actually, put in a prerequisite requirement that the regulator has to do before they can issue some sort of enforcement power, and it's impossible to meet that test. We certainly had that experience in Hong Kong where in an attempt to get a sort of to keep stakeholders happy, they put a test that we had to meet before we could issue proceedings against the company, but it had the effect that we could never meet that test. So we could never issue a certain type of proceedings just because the way it was drafted just made it impossible. And this can often happen even with the best will in the world, because people are busy working on a policy in a particular area and just don't understand or perceive that they've caused a problem in another area. So sometimes, for example, changes to general provisions about, you know, how prosecutions operate or courts work can forget about one agency that might be bringing its proceedings in that court and leave it out. We've had a few examples where information sharing provisions have been quite specific and have listed a whole bunch of people who can share information with other people, but inadvertently have left out some key agencies and sort of created big problems that people can't really do their job because the way it's been drafted doesn't give them access to the information they need. So I think any of those sort of things that regulators see in practice, having a good feedback loop so that they can feed that back into the policymaker. You know, hopefully you find lots of these at the draft legislation stage, but often it's not to actually get out there on the ground and you're trying to you know, implement a piece of legislation that you find some of these mistakes have happened. And then also there's a good regulator community. People have to work a lot with other agencies, so they may often have a sort of pre-existing link with another agency, and if you're the policy person coming in to do a particular piece of work, you might not have had any need to particularly link with the policy officer in that other cluster or other agency before, but a project might come up, and often the regulators are the ones who will have already had those developed links and can be your way into finding the right people to talk to when you need to talk to other agencies. So I think I'd sort of sum up the benefits of it is that it just gives you another point of view. I think it's really important to understand that people who are implementing legislation have a very practical approach. They'll be wanting to achieve the same objectives as you, but they will probably be a little bit more sort of focused on how will this actually play out in practice. And I think they'll also be, you know, sometimes they can vote with their feet. So if you have created some policy and some legislation that doesn't work, regulators, as I'll come to later, often have quite a discretion. They always have far more than that they can do than they have time and resources to do. And if they feel like something's been poorly drafted or creates a lot of barriers to implementation, you know, they just won't enforce that piece of the law, and you can lose all the benefit of your policy work if you find that regulators are ignoring what you've put in the law, you know, for good reason, not because they don't believe in the outcome, but just because you've made it so hard for them to actually do it. They'll be able to just sort of legitimately say, we've got lots of things we can do here, and this one is just too hard to do it the way it's been drafted. So from the other situation, I'll just get you to move on. India. So benefits of having the policy input. I think this is really a really important piece. I think I've seen too often, particularly maybe in some of those structures where there was quite a lot of independence between the policymakers and the people who had to implement the regulation, of people being handed down a piece of black and white legislation without really understanding what the purpose of it was, sort of getting it at the final stage or even as a draft stage, and sort of looking at it and it seeming sometimes incredibly complicated, sometimes not seeming to hit the mark on what you think the problem is. And so I think a good understanding from the people who have to implement legislation about what the policymaker was trying to do is really helpful for them in then going ahead and working out, okay, now I've got this piece of legislation, what's my regulatory approach going to be? What am I going to focus on? What problem was it really trying to resolve? And I can prioritize that in my regulatory activity. Sometimes you see a piece of legislation that doesn't seem very sensible or make a lot of sense, but if the policymaker can give you a bit of background about why this was put in, because it was to address a particular stakeholder concern, or it was a sort of bargaining chip that had to be used on the passage through the parliament, I think that really helps a regulator, rather than sitting there going, why the hell did someone put this in the law? If you can sort of look at it and go, okay, I understand where that was coming from, and that was part of the process, the policy making process, and why there might have been, while there might have been some better or quicker or easier way of doing this, we've done this for a good reason. And then that means that then the regulator again can adjust, you know, what they do, how they implement the law. They can understand why this why the legislation is the way the legislation is, even if it isn't the way they would do it, and then they can, you know, take a proper approach to achieving what outcomes you wanted to achieve. I'm pretty sure all of us on both sides of the regulatory and policy making fence know that, you know, we get trapped in this situation often where maybe it's not the most ideal way, the way the legislation comes out in the end, but if we can understand the background, we can sort of try and make it work as best we can. Again, policymakers can often help regulators to understand that there's just a part of a bigger picture, bigger pie. So sometimes, you know, there might be a regulatory piece that is actually just a small part of a more general policy outcome where a lot of work is being done on other, you know, a legislative scheme that has a whole lot of requirements that aren't regulatory requirements that people are going to do, and then the policymaker can sort of explain why the regulatory role is there and how that fits into the overall scheme for attacking a particular problem. And then finally, a very good outside view and check and balance. So if you know, a policymaker sees that a piece of legislation is not being used at all, or being used in a way that wasn't the intention, or seems to be being used, you know, part of it's being used a lot and the other part isn't, I think they probably have the sort of big picture view to say, well, why are we just prosecuting people for this particular offence and these whole bunch of other requirements are not being followed up? And then that can lead to a good dialogue about, is it something that's difficult for the regulator to implement, or is it just a misunderstanding by the regulator about the range of options that they have? But very good at providing an outside check and balance. And just, I think if you're ever doing sort of law reform proposals, really need to have some good engagement and understanding of what's happened in the past and why has something worked or something hasn't worked. I might get you to move on to the next slide. Okay, so just a few issues. When I was liaising with Louisa about this, she was sort of said, I think everyone probably agrees with the proposition that collaboration between policymakers and regulators is a good thing, but there's probably some good reasons why it doesn't always occur the way it should, or might not always work out in practice. So just a few things that I thought would be worth mentioning. One is that some regulators can have a bias towards more regulation. This is a polite way of saying that sometimes people who are regulators see the world through a pretty black and white lens and can sort of assume that the only way to change someone's behaviour is to prosecute them or take some, you know, enforcement action against them. And so they can sometimes tend, when you bring them a problem, to assume that the best way to fix it is through a quite strict and black and white sort of regulation. And I think the policymaker's skill is in working out that that's good information to take into your decision-making process, but don't automatically assume, notwithstanding that the regulator will have all that industry on-ground experience that I talked about earlier, that they necessarily have come up with the right answer. And I've certainly tended to see this where we've had sort of proposals that you know, seem very good to me, to be pretty sort of modern, up-to-date regulatory approach, principles-based types of regulations. And then it goes out for some consultation with the people in the regulator teams, and it comes back looking more like, you know, pages and pages of black and white requirements that the person has to comply with, rather than a sort of principle-based approach to particular types of behaviour. And that's probably a function of a regulator person thinking it's more straightforward and easier if it's all black and white rather than the sort of approach where you want to be flexible and adaptable and think about the overall diversity of economic circumstances people will be in that leads you to think principles-based regulation would be appropriate. So I guess just always be a little bit on the guard that a regulator can sometimes tend to bias towards regulation and particularly towards black and white regulation. The next one was getting this balance right between providing sufficient certainty about what the law is, but leaving sufficient discretion with the regulator. I think sometimes people who haven't had a lot of experience in regulation underplay the amount of discretion a regulator has. And when I'm talking to people about why I've had a career in regulation and what I like about it, I sort of say a lot of it's to do with the sort of intellectual challenge that comes with the fact that you've got to make decisions all the time about which of the many contraventions of the law you will see every day you take action on, and then the decision about what sort of action you take in relation to that, and the decision about what sort of risks are the worst risks in the market that you've got to deal with and which ones are the easiest ones. And I do like the idea that it's sort of this tapestry that you're weaving of a whole lot of individual decisions that you're making as a regulator that then leads to the overall regulatory stance that you have, but also leads to the overall way in which you've intervened in the market. It's sort of a whole lot of small discretionary decisions that you'll make that actually gives the overall picture of your approach to dealing with a particular problem. But I think sometimes from the policymakers' perspective, they don't realise how much discretion a regulator will have. Even if you're pretty black and white in your policy and in your legislation about what the regulator should and shouldn't do, the regulator will still be able to decide whether in fact they do that and how they do that. And I think it's always, you need to understand that you need to leave some discretion for the regulator. You can't require them to take action. I've had some examples in legislation where it says every complaint that you receive shall be investigated. Of course you can't. We were getting thousands and thousands of complaints, so we just renamed investigation to mean we'd read the letter from the complainant. That was our investigation. We just retitled what an investigation was, which wasn't the point of the person who wrote that. And I think they just didn't think through, the practicality of it, and also the appropriateness that a regulator should have a discretion to say some complaints that come from some consumers or some members of the public won't be about a breach of the law or will be so de minimis that they're not worth following up in the whole scheme of things, and you need to leave that discretion. So always good to have a discussion about understanding what sort of guidelines would help the regulator in exercising its discretion, but not being so prescriptive that you actually cause some perverse conduct from the regulator because they just can't comply with the requirements you've put there. Linked to that is what resources might be needed to implement their policy. So I've never, in my many years of working in regulators, had a team tell me they've got too many resources. Always a challenge for a regulator that you will probably have more conduct out there, more complaints, more people needing attention, more cases to take to court than you ever have enough resources to do it. So it's not very helpful if the way in which a policy is conceived of is on the basis that the regulator will be spending a lot of time and effort and money to do particular things. It's incredibly resource intensive to run a prosecution. So I really sort of encourage people to think about what other remedies apart from criminal prosecution you should put in a piece of legislation, because if you just confine it to a very small types of remedies, the numbers of matters the regulator is going to be able to intervene in are going to be very slight. If you have some more flexible, adaptable remedies like enforceable undertakings or getting some other outcome for people that doesn't rely on running through the criminal law system, you probably get a far more level of activity. So I think it's always good to understand that. It's very common, as far as I can see, in the New South Wales government for new law to be made, and everyone cheers and implements it, and then they give it to a regulator, and we get sort of no resources whatsoever, or hardly any, to implement changes, particularly changes to legislation. If it's a completely new scheme, sometimes you can then make a good budget bid, but if all you're doing is changing a pre-existing law, but you're actually adding to the regulator's burden, it might actually have the unfortunate consequence that some other regulatory activity gets lost because people just don't have the resources to do it. And then the final one is just remembering that sometimes regulators are a little bit removed from the political process, particularly compared to people in policy teams. So when you're discussing it with them, they might not always be as keenly understanding of the policy environment. I've seen circumstances where regulators have got quite upset that their suggestions have not been taken on by the policy team. And I sort of look at it and think, well, I can understand why the policy team hasn't taken your suggestion on, because it won't make it, in the minister's office for more than 5 minutes. So there was no point putting that suggestion up. And sometimes I think regulators just, because they're out there, on the ground, they're not dealing with politicians and political process as much. They just might not have that understanding. And again, this is one where it's good to, collaborate and talk about it. And the more you can educate regulators about the political environment they're operating in, I think the better regulators they will be. So I might just move on to the next one. So I've just got a couple of examples that the team in Better Regulation Division have put together for me, where we did actually do some good collaboration. So they're sort of examples of good practice. The first one is medical gas regulation. So this one arose, I think some of you may recall, a dreadful situation where a baby died and then another baby was severely injured when there was a gas pipe in a hospital that was connected to the wrong outlet, and so instead of getting oxygen they got some other gas. SafeWork took a prosecution against both the gas installer but also the company that the gas company whose pipes they were, and we lost the prosecution against the gas company. We were successful with the installer. He pleaded guilty. And so it was a sort of tragic incident, and there was perceived to be potentially a failed regulatory outcome. I'll just do a little sidebar there. I don't actually think because you haven't always succeeded in a prosecution, you have failed, because unless you're pushing the envelope a bit with some of your prosecutions, you're never actually testing the full extent of the law. And I've had previous bosses be quite concerned if you have 100% success rate with your prosecutions. At the ACCC, Rod Sims was always quite worried when we were up in the 90% success rate, because it showed we weren't pushing the envelope on the law far enough. The year we got down to 50, he wasn't so excited either. But anyway, so the point there was that there was a lot of sort of context around this, that was a very tragic incident and seemed not to maybe have succeeded the way we dealt with it under the law as it was. So there was a decision to require a license for the people who are installing medical gas, and an announcement was made with a very short time frame. And I think that sort of was a good, in some ways, terrible as it was for the team who had the short time frame, it was actually really good impetus to get everyone who was going to be involved in implementing this in the room together. So the policy team in Better Regulation Division, the licensing team who was going to have to issue these licenses, the people who were going to be doing the compliance and enforcement work. But I think most importantly for us, and it was a really good lesson, the people from the IT area who were going to actually have to build out the IT system to add this class of license to the licensing database, the government licensing system. And that just really helped getting all of those people in the room at the same time, because everyone was going to have a little piece of the pie, and unless they actually all got together, we were never going to do it in the 6-month time frame. We actually had quite a formal governance model for this one, so it formed a proper steering committee and a working group, had a page on Teams where information could be shared, and so really involved everyone we could think of who was going to have a role in making this happen. Had the benefit of the Safe Work team who'd done the investigation and the prosecution, because they had a whole lot of industry knowledge and background that they could bring to bear for the policy team. And then our licensing teams who had obviously no knowledge of medical gas installers whatsoever, but do a lot of other similar types of licensing of plumbers and gas fitters and things like that, were able to help as well. And then the stakeholder engagement could be quite joined up as well. And, when you've got the stakeholders in the room, they don't just talk about policy or just talk about implementation or regulation. So the benefit of having our whole team in the room with the stakeholders meant that everything that they raised, we could bring. So that was a great project done in a very, very short time frame, and we managed to issue our first license within the 6-month period. So it was from announcement to legislation to having a system where people could apply for a license and we could issue it all in one go. Might move on to the next one. So this boarding house statutory review it's a slightly different model, because this involved not just the team in Better Regulation Division who have a role in regulating boarding houses, but also our colleagues in Community and Justice, Fire and Rescue and the councils. There was a review of the Boarding Houses Act, and I think part of the trick here was that boarding houses is a slightly old-fashioned way of talking about shared accommodation, and part of the review was deliberately looking at a whole new model, and not just tinkering with the margins of the current boarding houses legislation, but really looking at what sort of accommodation options are there for people who might have traditionally been living in boarding houses, all the different pieces of the pie that all these agencies have, and making sure that we had a very joined up approach. Again, this was really helpful for the stakeholder engagement customer focus piece. Obviously, some of the customers involved in this area are quite vulnerable ones. And it's very confusing for a stakeholder if they sort of have to understand that fair trading has certain regulatory requirements around boarding houses, but then we don't do it all. Some is done by Fire and Rescue, and then this other little piece of the pie is done by the local council. And so the ability, again, to have all these people in the room at the same time to discuss it all with stakeholders and have give the customer one view of government rather than a multiple view of government and understanding, really meant that the review moved on well, but also put us in a really good position now the review's been done to do the next steps. And again, absolutely essential to all of this was, having some ICT people in there, because it became very clear that part of the success of the outcome was being able to integrate some of the information about boarding houses into the e-planning system, which is in DPI, not with us. And so therefore engagement with people, the e-planning people, also really gave us a great option for thinking, rather than thinking we needed to do our own information sharing ICT build, that there was a system in government that was ideal for the purpose, and local councils and Fire and Rescue were already engaged with it, and fair trading. So just move on to the next one, which is my final slide. So I think what we would say from our experience in Better Regulation Division over the last few years is absolutely do it as early as you can. The more you can get other people involved in the policy making process, the better. Always a bit of a trick, particularly if you're on a really short time frame, but I think skimping on that engagement with the regulators probably doesn't pay off in the end. Getting the right people in the room, so not just people sort of, at the higher levels, but trying to get some frontline people in the room, get the ICT people in the room, get some of the people who are doing the actual processing of the license or whatever it is that your policy is about, to understand from them how they will see the world, what challenges they will see, if they will see your great long list of requirements as a burden rather than a benefit, and just understanding all of that. I think we found it quite good to actually sort of set up formal collaboration structures like steer codes and working groups, rather than just sort of ad hoc talking to people from time to time, because it really does make sure that you you know, come back again and again as the policy develops and people get an opportunity to look at it along all its stages, and that you have the benefit of not just one-to-one conversations with different people, but you have the group there. And finally, the engagement. I think internal engagement's really important. We've had a few unfortunate examples where, you know, the laws changed and the policy team have done a great job getting the legislation through Parliament and getting it proclaimed, but the people out on the ground, maybe out in the regional areas who are enforcing the law, never knew that it did. And we have embarrassing situations where, you know, they issue a penalty notice that is no longer valid or something like that, just because we haven't done our internal comms properly. And then the external communications, again, the sort of stakeholder engagement piece, the earlier that you can get you can show that the stakeholders that we're a joined up operation, both the policy making and the regulation, I think the more help that is with the communications. So I might leave it there, and I think, Louisa, you're going to organise questions.
I am, and thank you very much, Rose, for sharing your insights into the really important relationship that we as policymakers need to have with regulators. So if you have a question for Rose, please put it into the chat and I'll coordinate questions. So whilst people are kind of thinking of the questions that they might have, I'll open it up with one myself. So Rose, I don't know whether this is an indication of the longevity of regulators, but I often find regulators, you know, have been in their roles much longer than policy officers. And it's an important thing, I think, to establish trust with those regulators. Do you have any tips that you can pass on for building trust?
Yeah, I think that is a really good, important point. Often people who have a sort of regulatory career get very devoted to their particular area and stay for a long time. And I think that, you know, because they've got great knowledge of both what they're regulating, but possibly also the legislation, maybe even so than, you know, a new policy maker, it can actually be sometimes a bit daunting for a policy person to have to start to engage with them. So I would sort of say, show respect for their experience and longevity, because, you know, sometimes the language they talk might be a little bit different to what you're used to in your policy teams, but they've still definitely got something to contribute. But I think also just, you know, show a real interest in sort of explaining to them the problem that you're trying to solve for. I would say most of the time they'll recognise that it's a problem as well. Sometimes they might not, because sometimes people who've been doing the same sort of task for a long time can get a little resistant to change. But I think if you sort of explain where you're coming from and just give them the picture rather than sort of just asking them some random questions without a context, that can really help, because sometimes it's a little bit irritating if you've just got someone asking you these seemingly random and maybe not very understandable questions about something. I think it's the engagement rather than the sort of sucking the, you know, you want to get the information, but you need to do it as an engagement rather than a fact-finding process. And then, as I said, you know, absolutely listen to what they have to say, but sort of also be understanding that because they've come from that long-standing background, their view of what the world is might just be a bit different, and possibly they haven't had as much exposure to sort of more modern legislation and principles-based approach to things than you might be used to. Yeah.
That's very good advice, I think. Okay, we have a question from Susan Reid. Susan, would you like to turn your camera on and ask your question?
Yep. Thank you, Louisa. Hi, Rose. Thanks for that presentation. I really enjoyed it. It sparked lots of thoughts and ideas. I should have said I work at DPI, Department of Planning, Industry and Environment, and my team is responsible for developing the plastics plan. And my question is about, do you have any experience or tips for working on drafting legislation that also may seek to explore harmonisation between other jurisdictions as well? So do you have any, you know, it's not always possible, but just seeing, you know, what you have discovered as some.
Yeah, we've got a few things. We've got the Australian Consumer Law, which is a harmonised piece of legislation, and we have the Work Health and Safety Act, which is also a sort of harmonised but maybe a little less consistent piece. And I think that's a really good point, because I think sometimes regulators have some good relationships with other jurisdictions because they have various sort of regulatory forums, and they can often be the way into finding out what's happening with other jurisdictions. Having come from the Commonwealth, where you know, we used to sit there going, why are all these states doing all these different things? I've changed my perspective a bit now as to why sometimes, you know, as a state government, you might need to do something a bit different. But I certainly do think there's real opportunity to use those regulator networks, because pretty much in every type of regulation, there's some national get-together body where they all compare notes on, you know, the weird policies their policy people give them and things like that. But also will give you a good sort of way in to find out who it is that would be good to talk to. And in the consumer law space, we have sort of quite a you know, vigorous policy group, and then quite a vigorous operational group, and then someone comes to each other's meetings, and that really helps as well, because we do sort of then get the crossover between the national ops people and the national policy people, and that really helps.
Great, thank you.
That's okay.
We now have a question from Tim Gilbert.
I think you're on mute, Tim.
Sorry,
Okay.
caught again. That's only the second
right.
time this year, I might say. I've been going
Pretty good.
Yeah. My question is, I've been in regulation now, you know, for going on 30 odd years. So I'm from your side of the bargain here, Rose. And in my time, there's been this separation between policy and compliance and enforcement agencies. Now, whether it's good or bad is another thing, but I guess my question is more of a statement, but I'd be interested in your view about whether, like, when we do policy and ledge, we're meant to do a regulatory impact statement, and I just wonder whether it could be a bit more, or you think it should be more codified to actually address some of the fundamental questions that are often encountered by a regulator and practical issues encountered by a regulator in implementing the law. So basic things like, for us, for example, significant cost burdens are imposed by legislation and changes in legislation. Work health and safety issues, not just for us, but for the regulated community as well. And also an understanding of where the policy sits in the context of other tools that are also being used to give effect to the policy outcomes desired by government. I'm interested in your view about whether that should be codified as a part of making policy in the first place.
Yeah, I think it's a really interesting idea. It sort of taps into a little bit about sometimes what is called regulation and regulatory impact statements are probably a bit of an example of this. Is people think of the regulation as the actual laws, and so when you do the regulatory impact statement, you're just trying to sort of do some assessment of the economic benefits and costs of the law itself. And it's sort of it's that fallacy that a lot of people have that, oh, I've made the regulation, I've solved the problem. And I keep going, no, that's only the beginning. You actually need a proper plan for implementing and a really good understanding of, exactly what the implementation costs and risks are and the likelihood that it can actually be implemented successfully, and the other sort of things, things that will happen if you implement this, what will happen elsewhere in the market. So I do think it's a really good point. I've sort of come across that phenomena, particularly in the environmental space, where people would impose an environmental regulation and then be very happy they'd saved the, that particular piece of the environment. And I'd go, well, not until the compliance team goes out and checks that someone's actually doing it. Have you saved that, particular species or whatever? Yeah.
Thanks, Tim. We have a question from Megan Ganesh. She's from New South Wales Police, but she's unable to turn her mic and camera on, so I'm going to ask it on her behalf. She says, in relation to more modern regulation principles, do you think less regulation is better?
Look, I probably am, in favour of more principles-based regulation. So I guess, you know, I get quite frustrated, for example, with the fact that we have a general law in New South Wales about misleading and deceptive conduct, and people should not mislead and deceive consumers. And then we have literally thousands of little regulations in fair trading that say, if you're doing this, you've got to have this very specific sign on your wall, and if you're selling this product, you've got to do this very specific thing. And you think all of it is in the aim of not misleading the person that's buying the product, and we could deal with it with the general law. And so I do sort of tend to think that the idea that there's a lot of red tape around it probably a true one, and it's sort of a symptom of people having a very specific problem that arises and trying to deal with it very specifically, and not stepping back a bit and asking the regulator, could you deal with this problem as the law is already? So I'm not sort of against the need for regulation, obviously. I think there's lots of examples where the only way to change behaviours or get markets to work properly, or for people to transact in a proper way, or fair conduct to happen, is to have regulation. But I do think some of the micro regulation that we have, it's not very helpful, and it's very frustrating for people who are regulators to be going around checking, you know, that someone has the exactly right size wording on a sign somewhere, rather than checking, is this person telling people what they need to know?
There's that idea, I think, of good regulation, and probably be good for policymakers to read up on that in interacting with regulators. We now have a question from Megan Cody.
Hi Rose, thanks for the presentation. I'm currently in DPI, but have a background in environmental regulation and regulatory policy making as well. So interested from both sides of the sort of you know, development of policy. Can you advise policymakers and regulators, based on your experience, where do you go and to stay on top of best practice, innovative, emerging regulatory policy making practice that both regulators and policymakers could make use of?
Yeah.
Thanks.
There's a really good ANZOG community of practice for regulators, but they're pretty open. You don't have to prove that you're a regulator, you know, or specifically a regulator. And they've been doing a great job. Particularly, actually, COVID's really helped, because they've been able to tap into a lot of overseas speakers at webinars, similar to what Louisa was mentioning you're having here. So that ANZOG community of practice, you know, look on the ANZOG website and you'll find that page. I think they're really good, and we do run, when we have been able to, some events face-to-face as well. I think it's sort of interesting because in some ways regulation hasn't been sort of seen as a separate professional sort of arrangement, but that's starting to happen. But I would say, I actually think that ANZOG and the various webinars and the you know, they keep up with the sort of latest ideas. New Zealand is always a good place to go as well. They're pretty out there in terms of how they approach regulation. I always think they're a really good role model. So often sort of look to what they're doing, and, you know, people writing about what's happening in New Zealand. For some reason, they seem to be a bit ahead of the game. Maybe it's not having to deal with a federation helps them a bit. And then, you know, there's sort of interesting stuff around the world, but it's probably a bit specific to particular types of regulation. Yeah.
Thank you.
That's okay.
I'm really enjoying this Q&A session. So we're going to keep plowing ahead. We've got a few more minutes. Celia Murphy has a question for you.
Hi Rose, I work at the Office of Sport these days, but I've worked in regulation for a long time. We have lots of functions in the Office of Sport, and regulation is just one of those. And so often it can be hard to engage ministers where there's lots of things attracting their attention, and especially when there are sexier things like funding announcements and fun things. So any tips that you've got on engaging ministers in the trickier conversations about regulation?
Well, I think it's always good to sort of tell a story if you possibly can. to 2 points. Once, when you have regulatory successes, sometimes because it can take quite a while for something to work its way through the courts or whatever to get the outcome, people have lost interest. But when you actually tell the story, it's actually quite interesting about what went wrong, what was the solution, what did the investigation find. But I also think there's probably some real opportunity in sort of, again, telling a story but explaining what's going wrong out there if you feel like regulation isn't working and you need to change it. I sort of feel like the challenging conversations I have is, when the minister's office think regulation is the answer to the problem, and trying to get them to step back a bit and think about other options can often be the most challenging part, and explaining to them that, the law already allows the regulator to do this, but this is perhaps why the regulator wasn't able to solve it in this particular case, and try and focus some attention. But I do find the storytelling, there's nothing like a very ugly safe work accident to get our minister's attention. People might not have other sort of things like that to talk about, but I think, it is really interesting about what actually happens on the ground when the law hits people's lives and how it fits together. Yeah.
And I think we have time for one last question before we wrap up. So, Jamie Morton, would you like to ask your question?
Thank you. And thanks, Rose, for a great presentation. Yeah, look, I was just wondering or interested in your thoughts on, I guess, trends in civil versus criminal penalties in managing behaviours or regulating, often in when working, I guess, with environmental related offences or natural resources offences. The burden of proof associated with criminal can sometimes get in the way of actually managing the behaviour, and obviously is also very resource intensive. So you're just interested in your thoughts on those trends.
Yeah, I mean, my natural bias probably over my career is, more towards the civil side of things, because, as you say, that burden of proof issue, but also just the, the procedural issues with the criminal prosecution can often end up with a monetary fine that's not actually that big compared to what you can get in a civil case. Doesn't actually change the person's behaviour, it's just the cost of doing business. It's sort of interesting because I've seen sort of the trend towards civil, and I think particularly the flexible outcomes that you can get in civil remedies, where I've seen some really good examples of, compensation payments or people having to do communications campaigns and things. That's one of the remedies. So you do get a really flexible remedy that's fit for the problem that you're solving. But then you do still come back to the old idea that if you want to change an individual person's behaviour, a criminal, there's nothing like hitting them with a criminal record. So I did see the trend at the ACCC where it sort of went from being very civil to, in the end, some criminal penalties for cartels, just because the civil penalty just wasn't, biting the way a criminal one can. But I do feel like my experience in the state is that there's a bit of a bias towards criminal remedies still that overstates the benefit of, a lot of pretty small scale prosecutions, and I'm not really sure what actual impact you end up having from doing that over and over again. Yeah.
Okay, thanks, Rose.
That's a really interesting kind of point to leave it, isn't it? What is the overall kind of outcome or the impact that we're having through both our policy and regulation? And I think that's the shared kind of perspective that policymakers and regulators will bring to bear on a particular problem, and I'm sure you'll all feel inspired to renew your efforts and to focus on those outcomes. So on behalf of the community of policy professionals, I wanted to thank Rose for taking the time to speak with us today and sharing her insights. It's been really fantastic, and as I said, I really enjoyed the Q&A session today.